involved discussions from pharma industry here in Croatia, and really very, very open discussions about the some challenges that they have and innovations, especially in the manufacturing process of drugs and pharmaceuticals. Today's session is really a primer session. So the introduction to the technology transfer to research commercialization and intellectual property management. Tomorrow's session is going to be about starting and growing a spin-off company. So really about business development and business creation in bio and health. And of course, we are going to finish with the 2-day course. I'm sure some of you signed up for that as well, where you will have a hands-on chance to practice a little bit of the concepts that we have learned and really to prepare a presentation then for industry or for investor. So the idea of today's session is to be a primer, and we have 2 presentations or 2 sessions. So I will start first with the presentation on technology transfer or on research commercialization for about an hour. Then we will take a short break, and then my colleague Donatella Verbanac from the Faculty of Pharmacy and Biochemistry will take over for a bit longer session about intellectual property and how you manage it in different aspects, whether it's in research, whether it's later in commercialization. I hope that you can all hear me, and I hope that you can all see the chat. Please feel free to ask questions in the chat. I will try to keep track of them. Maybe I will be able to answer some of them during my talk, but if not, then I will see it at the end of the talk, and I will address all the questions that you have. So please use the chat for that. And with that in mind, let me start my presentation. And yes, and we have another point, which my colleague Ana Branca from the organizers teams sent. So please rename yourself. This is especially important if you are taking part in more sessions and if you are aiming for the school certificate. For the school certificate, you have to take part in the course and at least 2 of the 3 webinars. So it's very, very important that we know who you are. All right. Let me see how does it work, and I hope. Ana Branca, can you confirm that you're seeing the screen? Yes, all right. I might not see you actually. All right. Yeah, and the problem is that I don't see the chat now actually. So yeah, I will address your questions after I finish the presentation. So please ask them in the chat, and then we can have a discussion later. So the idea of this introductory session is really oops. Okay, sorry, I'm trying to. Okay. All right. So the idea. And I'm clicking and I think moving forward. Sorry about that. All right. So idea about this first session is really to give you an introduction to research commercialization, to really address some of the like main terms, but also I would say the main factors. So what is it? How do we go starting from this academic perspective, from the research early career research perspective? How do we go about it, and what do we have to keep in mind? I didn't introduce myself in the beginning. So my name is Vlatka Petrović, and I'm the head of technology transfer office at the University of Zagreb. And I have been doing this for 12 years now, being with the technology transfer team at the university. Before that, I was a researcher. I was working at the Ruđer Bošković Institute, also here in Croatia. So really doing PhD work in molecular biology, in molecular genetics. And after that, after I moved to the technology transfer office, I had a chance to work with researchers from, I would say, all fields. So not only biology, but from engineering, chemistry, electrical engineering, civil engineering, And I would say some of the things that I will mention here really do apply, in whichever field you are. Some may be more life science specific, but most of them are really, really universal. And also when you discuss these things with researchers in other countries or with industry in other countries, as you will see later in the slides, you will also see that some of that most of these themes really repeat, and that this most of things are universal and important everywhere. So just briefly about the University of Zagreb technology transfer activities. We do several types of activities. One is that we can do technology transfer on behalf of the university, meaning that we actually support university as a legal entity. Quite often, we actually work a little bit differently. We provide advisory support to university faculties, as the faculty is the legal entity, and in many cases IP owners, something that will happen, that will Donatella, my colleague Donatella, will also explain in more detail. And then this sort of support where we jump in can be initiated by the researchers, by the faculty management, by the industry. It really depends. And we also discuss the scope depending on each individual case. We also work quite a lot with SMEs. We are part of this national POC fund as a recognized center, so working as applicants to this funding stream and proof of concept. POC is proof of concept, and this stage is very, very important for any product development, for any innovation development. Also doing a lot of training education for different groups, for students, for researchers, and matchmaking and events that really bring businesses and researchers together. We are also what is called an EIT Health Hub, and you have probably noticed these logos on my screen as well. So both EIT Health and EIT Manufacturing are supporting this school in the sense through our work, basically. We have both of these, are knowledge innovation communities that have been set up by and supported by European Institute of Technology, that's EIT, but also that have been set up and supported by their members, because they're set up as a public-private partnership. And EIT Health has over 100, I think about 150 members, including industry, universities, research institutes from all over Europe. The ideas who are then creating programs and taking part in these programs to all brought together about this joint health theme, and really improving the quality of life of all the citizens of Europe. So the idea of the hub is really to bring closer these activities of this network, of EIT Health Network, to some countries that have not to date been maybe so active. But the hope is that basically through our activity and through connections that we build for local innovators, there will be much more participation in the activities that this network has to offer. If I will just mention briefly that it's really through the EIT Health there can be access for additional funding, especially again to proof of concept, which I mentioned is very, very important stage in innovation development. There is an annual call. This year it's closed, so we are waiting now for basically for next year, that supports local collaboration in R&D to bring some innovations closer to the market. The second is really business creation programs, and EIT Health has the whole array of these programs that you need to sort of find your place in this array where you fit the best, and then apply and take part in programs where you are selected. So starting from very early stage incubation to again the stage of this validation, testing the concept with users, or to the scale stage and entering your market. But of course, to be able to do all this, to participate in all these programs, you need to start. And that's why partly this is why we have a session such as this, as really starting orientation to help you on your way. And just very basically, there are so many definitions. And sometimes they are important, sometimes they are not. I think for innovation, it is important, I think, to maybe communicate that not all innovation is technology. So yes, technology innovation that is thought out or created in the lab, or on a computer is very important. But even so, for the companies, it can be improvements in the process as well, or it can be even improvements in the marketing method or organization. And we do have to keep that in mind, because the companies are really looking um, at all of this from their end, and trying to find, you know, dealing with all the challenges they have in the market. Which means that sometimes they can be open to new technologies, but sometimes also, they are more cautious, because every introducing a new technology may also have its costs. So, the other way of looking at all this array of technology transfer activities is really to see what can be involved. And I like this diagram that is, because it is very, okay, it is very small, but it is also very comprehensive in an essence that it really does show that, from the research institution perspective, it is all about the impact on the economy in the end, and impact on the society. And the way to do it is really through the research and the new knowledge that is created in the public research organization context. So really, it's publications that are important, but also materials, technology, all the innovations, and also all the skills of both the researchers and the students. And then we have this array of knowledge transfer activities that really needs a partner. It needs a partner from the commercial sector, or from the government, or public institutions, to transform it into products and services that can then benefit the users. And as you can see, there is a whole array of these knowledge transfer activities. So basically, I'm just repeating this middle section of the presentation for you to have a better look. And we can, all of these are quite important, actually. And need to be taken together. What happens usually in research context is that we tend to start with the solutions, and that is also quite normal, and that is why I will also start my presentation like that. But then we will come back to this slide, I would say, in the end, to see how it all fits together. So when we start with with the solution, we are also looking at this, I would say, classical technology transfer process, from perspective of institution. When you have the invention, then you sort of see how to position in the market. Then you look for partners in the market, and then you license, or you decided to spin off a company, and then there is this financial return. Of course, the reality is a little bit or much more complex than that, but it is important also to sort of understand this basic, even though it's a little bit linear process. So, obviously, solution is something that is created, and really depends on the creative effort of all the individuals involved. Well, I'm sure that it can involve a lot of the lab work. It involves lots of collaboration as well, and science is much more collaborative now, with people with different groups, but also with groups from all over the world. And you will see, especially, and I think later on also in my colleague's presentation, how important it is, for example, to document what is happening, so that you know later on what do you have, and to be able to communicate what do you have to all the partners later. So yes, absolutely, solution is the science, and is where it all starts. So from some sort of internal process or perspective, it is good, after you think that you have something that you believe has commercial potential, it's good to talk to somebody. And in most of the universities, there are technology transfer offices, there are knowledge transfer offices. Sometimes they're not called like this, but you have for example, like a researcher services unit, and then there is a person there who is in charge of technology transfer into intellectual property. And these people are your sort of first address to discuss your invention and to really have a chat about what you are doing, and to see how to move forward. There might be some forms involved. I'm sorry, and this is not because people love bureaucracy, but it's also because it is important at certain point to really document first of all what you had, but also all these other funding sources that you had, and this is relevant from the intellectual property perspective. The publications that were planned or are going to that have already been done or are planned, and really your thoughts, because in most of the cases it is really very important what the network and connections that the researchers already have. It is also very important to document all the creators' contribution. So this is and this first stage, the people from the TTO, from the research services office, they will sit together with you and really discuss some basic questions. And this is partly who owns the rights. Because if you really want to do something with the technology, you need to be sure that you are the one who can do it. And sometimes it can be a little bit complicated. For example, that there can be pre-existing agreements that the university has with some funding, whether it's a funding body or industry partners or others who are, that in some way influence what can be done with the technology. Sometimes it is completely free to manage by the institution, but sometimes there are restrictions, and that's why it's very very important to look at this, sort of to go back and see what has been happening. And part of this discussion is also this which IP rights may be relevant, because we are looking at the technology as a whole, but technology, this the big whole, it really can be sort of parceled out into this array of rights, and rights are really just intellectual property rights. They're just legal instruments. These legal instruments that can help you manage the technology that you have. And again, this is the topic of the next presentation, so I will not go into detail. But this sort of, looking very closely, what do you have, whether this is a patentable invention, whether this is something that can be copyrighted, whether this is really something that needs to be maybe confidential, whether it's know-how, it is very important part of the early discussion. And of course, the next comes is the market and commercial potential, because also very important in this sense are the solution characteristics, and this is something that we discuss with the researchers quite often, because um, it is very good to be able to quantify what you have, and I'm sure that you know this from the research as well, that really, when you are describing all, whether it's the methodology or the results, that you need to be very detailed and need to be very specific. And it is very similar like this in the technology transfer and working with innovation. So if you think you have something, it is very very helpful if we can first of all quantify some advantages, technological advantages, whether it's more accurate, whether it's faster, quantify if there are some drawbacks. And sometimes it can be like this, it can be, I don't know, it can be has a better yield, but therefore it may be more expensive to implement or something like that. So we need to really know the specifics. And this the line under it is very important, is how it translates into the benefits for the users. So knowing this technical specifications, yes, it's important for maybe for later technical discussions. But in the first contact with any users, with any companies, the focus will be on the benefit. However, and this cannot be stressed enough, good science is the key to good technology transfer and to good commercialization. Um, And it always comes back to that. So you can have all these preliminary discussions. At the end, somebody is also going to take a very close look at the science. One of the issues is this reproducibility of results, and this happens. And even yesterday, one of the industry speakers, when we asked him about some technology transfer challenges or specific cases that their company dealt with, really stressed this reproducibility issue, that not all the results in the lab could be reproduced in industry conditions. Sometimes, the idea, because maybe researchers are eager to report the good results they have, it doesn't necessarily follow all the protocols that the industry considers necessary to actually confirm a result. And this is a very, very relevant point. And what I put on the slide is quite old, but obviously they're still discussing it in 2020. As I mentioned yesterday, industry speakers specifically stressed this issue. And this really does, one of the reasons is this difference in methodologies, that in industry methodologies do have more different types of controls and very much stricter, I would say, validation criteria. Because science really does, it's sort of built on dialogue. So you come out with the results, then somebody else draws on that, and the scientific dialogue continues. But for the product development, for the industry, they really need to put everything into sort of a funnel and a pipeline. And that's why there are different types of control, and unfortunately, not all results can be reproduced. And this creates for problems for industry, and they can become more cautious, of course, in dealing with the university partner or with researchers. In some really higher stake situations, for example, when investor was looking to fund a spin-off company, they were known to actually to hire a contract research organization to reproduce some experiments, because why not, spend like 20,000-30,000 euros if you are planning to invest 1 million, for example. So it can happen. And so good science, quality science is very important, but also science that understands the requirements that then the industry has in driving a product to the scale up, to the production, and to pass all the later checks. And I think I've talked about the solution quite enough. So I will now switch to this other side, and this is the market and potential. And also one of the themes that we discussed in the session yesterday is what problem does it solve? So the problem is just as important as the solution, because if your partners, the industry partners you are talking to, don't think that the technology that you have can solve the issues that they are dealing, they will say, yeah, that's interesting. We will read about in the papers. Congratulations. And that's great. But we also want to have a partnership. You also want to work together. You want them to invest in what you are doing. And that is why it really needs to fit into what they consider to be a relevant problem. And that's why it's very important to talk to industry early on, not about the specific project. If you don't wish this, even that's also very, very good. But just to keep contact with industry so that you understand what are the issues and what is moving or competitive challenges they're dealing with. In most cases, these problems can be quite complex, and it can also be quite complex in terms of who is the solution going to benefit, and who also is going to pay or maybe buy this solution. So, for example, in healthcare, you really do see from the product manufacturer point of view, there is this is very classical. I mean, there's the patient who is going to benefit. There is the physician who is in charge of prescribing, so of choosing a certain course of treatment based on the patient's clinical picture. And there is, of course, the payer, which can be state insurance, or it can be private insurance, or it can be the patient himself or herself, who are actually paying for the treatment. So, for their perspective, all of them are important, and they all need to see a benefit into, for example, a new drug being introduced. So you are not introducing a new drug. You are talking about some technology with a pharma company or with a biotech company. But you need to also understand their positions and who are their clients, I would say. And these are all these. And in different fields, you have different relationships. So if you are talking to, basic chemicals company, that basic chemical company is probably a supplier to, I don't know, fighter chemicals or laboratory grade producer or something like that. So, but in most of the cases of the company that you are talking to also has this complex network of collaborators and also of their own clients. And they will judge your solution in respect how it does it improve their competitive position. And sometimes it can be very, I mean, this is unfortunate, but it happens. Sometimes the companies are reluctant to introduce new technologies because it can change their processes so much. And it can be their, for example, technology processes. If you are producing something in terms of volumes of millions of tons or millions of units, then of course, any change in a production or any change to the procedures you have can be quite significant. You will be reluctant to do it. Something could be something more simple. I mean, I've heard examples that people were reluctant to introduce in new technology because then it really requires you to sort of retrain all your service teams. So all the teams that will be then supporting the clients that this company has later on. And that also is a cost to a company. So you will have to find, and this is why it's very important to work with the technology transfer office who can help you identify those partners who will be open to collaboration. Very important question, of course, is the competition. And what we often hear, the statement, there is no competition. And that is not true. Because even if there is nobody who is doing this specific work or who has the specific results, there are other ways in which this problem is being solved. And that is competition as well. So it's not just somebody in the same technological field, it is somebody else who is solving the same problem in a very low tech way. It can also be. And this needs to be considered. And then when we are asking this final question, why is your solution better? We are not looking at just the technology. Yes, I mentioned technology and science is very important, but we are looking at this from the perspective of the user. Will this make it more, will this make it work quicker to me? Will it become more competitive? Will it be easier to work? Will the benefits I bring to my customers be such that really justify introducing this new technology? And this can be sometimes very, very difficult for early stage technologies to judge. And that's why I'm putting this in the next slide. This is maturity. And really understanding, especially when we are in the lab and we are at the stage in a public institution, there is still a long way to go. And especially, I would say, in pharma and biotech, but in other fields as well, there are steps that are necessary to bring something to the market, to have it produced, that maybe we cannot do at the level at the lab. But that's fine in the public institution. We just have to understand that somebody else is going to need to make those steps and invest all the funds and invest the manpower, invest the resources to actually then bring it to scale. And it might fail, as you see in the little cartoon at the top. It is not the same if you do something at the level of one flask or if you do something at the level again of the thousands and millions of tons. or if you do it as a prototype, if you are talking about the instrument. And even software, and we have found this, it is different if you are just uh, creating a coding a software solution to work once. So basically, it's important that it works. That's the sort of the end game. And when you try to move it to the product stage, it is really about the robustness. It is about reproducibility. Really about also having documentation for every line, for every stage, that you can troubleshoot problems if they happen later on when it meets um, clients. And also it is about satisfying regulatory requirements. And that is something that is, especially as we are talking about health, is very important. So it of course affects drugs, it affects devices, and rules for devices are becoming more and more strict. It of course it affects production technologies, because uh, again, pharma industry is reluctant to change things as if they might affect the final result as well. And just from the regulatory standpoint, they might require new steps then to ensure the quality, to ensure all the standards. And that's why, we need to appreciate that even though we have great technology, it's come in the lab, it still has a very long way to go. But this is not meant to discourage anybody. This is just meant to, I would say, maybe understand the industry position and understand the industry side, because we need the industry partners to take these further steps. And they need us to create, to, to give them new ideas, to give them new expertise and new solutions, because they are so focused on having these further steps run well. They might not have the insights that the researchers at the academic side have. So really bringing those two together is absolutely important. And I think I mentioned all these aspects of the maturity, and you can see the middle diagram below. So it's a technical, it's regulatory, but it's all market business, and of course the clinical component. So when you get all these things together, you can, I would say, start planning for commercialization. And this, all these steps, they don't, they do take some desk research. They might take some, phoning up people to best understand what you have, and then following on that, you are really planning. How are you going to commercialize? So which companies are you going to target? Are you going to target small companies? Are you going to target biotech? Are you going to target some specific section, of course, of the biotech industry? What is going to be your IP protection strategy? And this is going to, the going to mention in the next session. And of course, are you going to license it to an existing company, or do you think, a new company should be formed to really push this forward to the market? And one of these decisions is really whether your technology fits within somebody else's product range, or if you have this big new technology platform that can lead to multiple options. And in the second case, if there is a platform of technology and leading to multiple commercial options, it may be worthwhile really to start a new company around it. But if this also creates a whole sets of new decisions in terms of how are you going then to enter to the market, who 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 are going to be the founders? Are it going to be just researchers? Will they bring new people? Will they be more commercial people? Are these new commercial people? Yes, absolutely, they need to be brought in. Are they going to become co-founders, or are they becoming later on employees? What are you going to do about attracting investment? So quite a lot of decisions. And basically, if you want to put it all together, and this is a framework that you will probably see if you are staying for the course on Friday, there are nice frameworks and diagrams, and I'm showing a lean canvas, and you can use some other. So this is a very good, quick, and easy way to put things together, to sort of have on one page definition of the problem. It always starts with a problem, to be able to understand your solution, to be understand how your solution is unique, in comparison to others. This is what we discuss, competition, to really discuss these customer segments, what we talked about, who is this addressing, whose problems is this solving, and also these additional values that your technology does have. And then finally, at the end, you are discussing, the revenue streams and how are going to make money, and this cost structure, what it is going to cost. And this framework is quite helpful, and it can be used for a company, it can be used for a project, it really can be used by the researchers themselves to start, but also together with somebody from the technology transfer or with the industry partner, uh, to put all the things in one place, and to be able to sort of crystallize the benefit and the positioning of the technology. And if your decision is to look for new partners, then you, of course, you have to find them. And I'm calling this marketing. It can be called, there are different ways of calling this, but it is really, again, understanding the value. So all this preparatory work that we have discussed, and all these factors that we have discussed so far, and then following up for that, really identifying partners, but not now just talking about segments. So not just saying, I'm targeting biotech companies who are developing, I don't know, oncology problems for the oncology solutions, but really to have specific company names, to have specific names of individuals within the company that you are going to contact. And this takes quite a lot of detective work, because the bigger your network, yours as a researcher, but also your colleagues from the TTO, of course, the better off you are. But sometimes it really does involve just going or through the web, through LinkedIn, and looking who is the best person to reach, because all the companies actually do have forms online. If you have a solution, please just fill in the form, and you can do this. And sometimes they do respond, but this is very, very boilerplate, and this is very, I would say, generic. It is always better if you can target a company. And we have had a situation once when actually my colleague, who is Anna Branca, the one who warned you about the certificates, or sorry, you're putting your name in, did this legwork really, I would say, very, very detailed, identifying the names and the companies that we are going to contact. And we also had an excellent solution coming from one of our researchers, that when she sent an email, I think she got a response in 15 minutes. And that's not, I mean, that's amazing, So Anna and myself had a party after we got this response. That is not usual, that is not usual. Usually it does take a little bit more time, and some, quite often you don't get a response, and you have to chase people. So you have to send them an email, but then you have to call them as well. And yes, is GDPR making things more complicated? Yes, it is, of course. But really, the idea is that the more contacts I would say personally, or the more contacts you can reach through existing contacts. So somebody that that knows somebody else, so that you are not completely cold, that you are not completely unknown when you talk to them about this solution. It always helps. You need to be prepared, and so before making all these first emails and phones, you really need to have a little summary on 1 or 2 pages, a little presentation, on 10 20 slides most, uh, which can have non-confidential and confidential versions, and also like knowing what are the most important aspects to address to somebody. And that again, it really does pay to work with a professional who is in the research services office or in the technology transfer office, who can help prepare this, but also who can take some of make some of these steps and actually make these discussions and the first contact with the company. Yes, the researcher will come to the later meetings, absolutely, because we will need to discuss the research and come back to the science and come back what the necessary steps are there. But to make this first contact, it also helps to have this professional involved. I'm showing an example on very simple marketing summary, and actually it's so simple that it's not it was not professionally designed, and you can do this, of course, if you have like funds to do something which is a professional design, absolutely do it. But something very, very simple that just conveys the message also works. The important point is that you communicate the applications, that you communicate the benefits, and to show a couple of slides that demonstrates what is it doing, but not necessarily how is it doing, because this how is probably confidential and probably is the reason why you want to have a more commercial cooperation later on. So really to send your message. Um, and then from this starting point, you are going into hopefully into a discussion with the company. And that requires you really to understand a little bit intellectual property terms. And again, I will not go into details there because the whole next presentation is going to be about this. But really to understand maybe the basic, there is a difference between what we call the transfer or assignment of IP, which is basically a sale in layman's terms, like when you sell a house. And the licensing, which is permission to use, which can be, it can be similar to rent, I guess. But also to understand that licensing is not, it gives you more options, but that is great. And that also means that you need to understand all these options. So, because sometimes when you license it, for example, if it's an exclusive license, it's also that the result is that you yourself cannot use it anymore. So you need to really understand the terms of the license agreement, and now bringing in not just the technology transfer professional, but also the legal professional into the mix. And that legal person can be part of the technology transfer team. It can be part of the legal department of your university, or or any professionals that's brought in that can help. And but also to always understand that this is because it is an exchange and because it involves a partner, it really revolves around this trust and balance and understanding. And I would say to some extent also, of course, the flexibility to understand that there will be changes later on in the process. And again, I will not go into the details there, but just to give you an idea of what are some of the topics and what we would call the terms of the license agreements. And of course, who is it doing it? What are the parties? What is it about? And that is very, very important, and sometimes can be very, not so easy to define, especially if there is no formal IP like a patent that when you can link it to. It really is important to be able to clearly define the limits of this technology, because everything then later on revolves about this. What are you talking about, basically? What is the center of this commercial agreement? Purpose is important, because there can be different purposes for example, whether it's for manufacturing, whether it's production, and so on. Exclusivity, again, is it going only one partner going to have the right to use, or is it going to be multiple partners? And this can be mixed field of use. So somebody is really looking at oncology, but somebody is, I don't know, looking for in the same chemicals, looking for, I don't know, some other fields, whether it's veterinary or something else. And so you really can parcel things out by field of use. You can really set, of course, different territories, duration, how long is the agreement going to last, sub licenses. So is the partner you are talking to be allowed to sub license this? And this can be important. For example, if somebody gets it and can develop it, but they will not be the ones to produce it, they will need to sub license. And how are you going to then to deal with that? what are the reserved rights? Again, for research institutions, very important to keep the rights, even if you're giving exclusive commercial rights, to keep the rights for research and education. How are we going to deal with improvements? So lots of, I would say, issues and topics to address. And I will not, and then only then, basically, and looking for all this together, you come to various financial terms. Whether it's going to be deadlines, whether it's going to be milestones. Usually milestones are linked to development, which is, sort of a motivation for both sides. I would say that if you reach understanding the technology's early stage, but also, us wanting the industry to develop technology and looking at the royalty payments and so on. And then, of course, I discussed a little bit the spin out. And I would say in some level, from the university perspective, it is treating it as a license again, because the technology needs to be licensed to this new company. But in terms of, and also it needs to look at, the roles of the researchers who are going to be founders, maybe, who are, or most likely, but some of them are just going to be advisors, or they are going to be both. So from the university perspective, there are lots of this little, I would say, relationships then to sort out, in addition to this IP discussion that the university will be having. And then, of course, as a researcher, you have to understand that if you are going to be the founder, that you are now having a dual role, and that we have to be very careful about how to manage this and understand that, that the university or the faculty also needs to sort of protect its interest in this relationship as well. And of course, I mean, the last part, and which is, this business planning and execution, because this new company then really becomes a new legal entity, it becomes a new commercial entity, and it becomes an entity that needs to survive, that needs to succeed in the market. And especially, I would say, in the session tomorrow, you will be hearing stories from entrepreneurs who have started a company, who have grew a big company, from small start to a larger company, and what were the different factors what were different factors that were important in this journey. And some of them I've put on the slide, and of course, this is about this business model. So how will you make money? Understanding how where the funding is going to come from, who are the customers that you are serving, how are you going to be serving, so who is the team that is going to build the technology, about the networks that will allow you to reach more customers, but also to get new best team members. And competition for talent can be quite intense in spinouts. And then understanding, of course, the two big ones, which are the top, and this is both timing and financing, and both are important. Because especially, I would say, for a technology company, you do still have these development stages to tackle. So you need to have investment that will allow you to cover development, while also you need to drive development, as a result to be able to reach whether it's the final client or the next round of investment. So it really can become a very much balanced game. And one of the, and that is why quite a lot of, startups do fail. And that should not be a discouragement. People who succeed, probably they didn't succeed from first idea they had. There's this overnight success that, took 15 years to reach. And this is very, very real. But when we look at the reasons why startups fail, I think you can see what is the first one, and that is no marketing. And then ran out of cash, and then not the right team. So basically, the things that I mentioned on the slide before, ran out of cash and not the right team, yes, important. But the most important one is the one that we discussed from the beginning, I think. And this is this problem and the need of the clients for the solution that you are bringing. Again, crucial in startups, very, very important in the lab as well. So how would you sort this, from the lab perspective? And I think I also gave you a solution a little bit before, because if you want to understand industry, you really have to start talking to industry very early on, and have to start talking to industry, maybe not just on this project, but start talking to industry on some other project, and then 5 years later, this will help you to create the solution, or to create the one joint project that is really going to succeed. And this really means, like looking into all these options, whether it's the networks, whether it's collaborative research, control research, and so on. And also, if we are looking for this from the industry perspective, that's why I'm showing you now this the other slide, and this is basically what Bayer has on their website as some types of partnership. You will see that your industry also, is looking at multiple options, and is looking to tailor the options to the institutions. So, for example, they have joint labs, they have with academic partners and industry partners, they have license and research agreements, they enter into consortia projects, they even have their own grants program to be able to come, to reach researchers as well. And very, very important, again, for the both sides perspective, is to have quality interactions early on, because from these quality interactions you will be able to create this new partnerships. Also, sometimes it can be look very, very complex, and I will not go into details, but some institutions that are very focused on partnering with industry can have quite complex systems in how to do it, and they do it by really understanding the time frame. So understanding that for some projects it may be best to partner with other academic institutions. For some projects it is good to partner with industry, and actually, because this is still, I would say, uh, ahead of market, it's probably pre-competitive phase, it is a technology that can be licensed to multiple parties. uh, you can do it by partnering with multiple industry partners, actually, and to have agreements in place that will support that, even to have big joint consortia, for such projects. But also then to understand that sometimes, when you are looking at something very close to the market that is very on the development side, it is best maybe to do one-on-one, to do it with one industry partner, and to have it tailored to them and to their competitive needs. So this understanding, again, if you're just looking at the partnering, not the commercialization, but just the first partnering in R&D, understanding the time frames and understanding the industry needs, it becomes crucial. And to sort of bring it to the close, how would you find partners? Uh, it, I would say use any any legal and moral means possible, because you really do need to have to work together through multiple channels to reach this. And this can involve publications. So looking at the publications in industry, there you can also find names of, for example, researchers who are in your field. Looking very much at the patent literature, something you will hear in the next session. Also finding the names of the researchers, for example, industry who is in your field and who can be contacted. Scientific conferences, seminars. Hopefully, we will have live conferences and seminars very soon. Working, of course, through the projects that you have as a chance to demonstrate your competence, but also to build bigger networks. And this can be a long game. So if you're looking at very successful senior researchers now, please, consider, they started 20 years ago. So 20 years ago or 15 years ago, they were also postdocs, and they had their own first project. And these first projects were probably, or I would say definitely not as big as the projects they have now. So they were just starting with small pilot projects in industry, trying to find a way, or not even looking with industry, but looking at the scientific collaborations with strong science partners who will then help them build those networks and ensure the quality of the research that they have, because again, the quality of the research and skills of the researchers are the most important. And I will close really with the industry perspective in interacting with the public research organizations. And this came with, some discussions and interviews I had with big industries, so with big pharma, actually, to be specific. And trust, absolutely. And we start with trust, we end with trust, and also what we need to appreciate it might take time to make it and to build it, and it can be destroyed quite easily. So one needs to be very careful about it. We really need to safeguard their own professional standing and their own, I would say, standing in the professional community and when working with industry. Also, simplicity. Especially PROs or public research organizations, sometimes can be can get complicated. There are different researchers, different departments, different units. Um, you know, there might be different streams of research that the lab is working on. But for industry, it really needs to be very simple. It needs to be direct. And it needs to be really to communicate very much how much is this really benefiting all the parties that are involved. And again, quality of academic research. Again, researchers with the understanding of these goals. And I would say finally, administration that doesn't not hurt, that helps, and that is really there to support the process. So if the organization has all this in place, it will be, it will be quite successful in working with industry and working and creating joint projects, and then moving from those joint projects to other commercial activities. So with that, I will end. I will take you. I will thank you for all of your attention. I will stop sharing now, um, and and also we have a couple of minutes because we started maybe 3 or 4 minutes late to take a couple of questions. So feel free to ask any questions. I don't see anything in the chat. Yes, I do. Okay. Okay. How useful are NDAs when giving technology presentation to potential investors? How do you balance the fine line? Yes. So I would say if you are talking about levels of technology detail, uh, that uh, that would require an NDA. But to discuss an idea or to discuss, the end result, or to discuss on how it can be done in general terms, it may not need an NDA. And actually, especially if this is in startup community, investors do not want are not very keen to sign NDAs because they hear so many ideas. So just have this sort of a vision is not enough for to warrant an NDA, because from the investor's perspective, they will hear 100 more people in the next 2 weeks with very similar vision, and it will be impossible for them to track who said what. So NDA, I would really keep it for the key technology details, things that are, for example, if you are working with a patent agent, things that a patent agent will also tell you, never publish this before we file a patent, for example, or never publish this even if we file a patent. So really, really keep it for the technical. Any other questions? Okay, I will just then maybe follow up on this. Sometimes even your own publications can be your marketing, marketing documents, basically, especially because your somebody that you are talking to are going to be people in R&D industry. So you, from the university perspective, it is if there is something that has commercial value, it is important to file a patent. To be able to have this patent application in place, and this is something to reserve this priority date, something that you will hear about it later on. But then actually to, yes, publish the results and to be able to demonstrate that this is, robust. This was peer reviewed, the reproducibility as well, and we have quite often, included links to the publications in our marketing document, while we also put it in the marketing document. Yes, the patent application was filed and such. And this does allow you to protect the technology, but also to be able to communicate to industry the quality of your science. Okay, I think if there are no more questions, I'm not sure. Is Donatella? Donatella, are you with us? Can you join us? Okay, so Donatella Verbanat.
Yeah, I'm here.
Hi.
Shall we start now?
I think we can take a 5 or 10 minute break. So bio break for
Perfect.
everybody, and then to start 11:15.
Okay, can you see my screen or not yet?
We can see you.
Share, yeah, so I will share my screen with you, and then we can start in 11:15. Is that okay?
Yes.
Can you hear me properly? Okay, great.
Yes.
Thank you, Vlatka, for this wonderful introduction.
All right. So everybody take 11-minute break, and then we will all be back. Stay connected, and we will all be back in 10 minutes with Donatella's presentation.
Is it visible, Vlatka? Okay,
yes,
perfect.
Yes, it's good. It's perfect.
So
all right.
I will unmute now, and I will close my
video. All right. See you in 10 minutes. Okay.
Hello.
Hello.
So can we start now? It's
Donna.
11:50. Yes.
Yes,
Can you
I
hear
think
me?
it's yes, we can hear you great. And please go ahead and start. I might disconnect at some point and then come back, but Anna Branca will be here as a host for the session all the
Okay.
time.
I will minimize the screens from your side so I can really be concentrated only on the presentation. So very warm welcome from my side to everyone, and especially I would like to thanks also to Professor Jasmina Lovrić for inviting me for the second time in a row to present something on a Winter School of Research Commercialization. Well, before we start, I would like just to share with you some features that are present on my first slide on this title slide, which also has something that is related to the intellectual property. Well, I have here the title, I have my name, I have my affiliations, but I have three trademarks. One is related to the Winter School. Then I have one trademark related to the University of Zagreb and the other one to the Faculty of Pharmacy and Biochemistry. And last but not the least, at the very end of the first slide, before starting even with the presentation, I have put these two sentences, and these two sentences have been actually introduced to me by Professor Igor Gliha, who is the Dean of the Law School, and he very often participates in our presentations to the students for the postdoctoral studies at the School of Medicine, University of Zagreb. So my presentation will start with a little C and with these two sentences, and later on I will explain you what does it mean. So first of all, I can, hopefully, you all see the first slide. So basically this is just what will be covered and what I try to explain you about the intellectual property, how to balance whether or not applying for the patent, to understand a little bit more better what the patent is, how to apply and how to obtain the patent. You should also understand how to use the patents, and especially I will give you a few examples about the pharmaceutical and biomedical sector and patenting in this kind of industry, because previously for 10 years I was actually employed by the pharmaceutical industry. So I have academic but also industrial background, and I also have some experience in patenting and dealing with patents. Of course, my background is medical biochemistry, and my PhD is actually in biochemistry. Nevertheless, all of you having any kind of experience in science or in business, it's always very good to know something about the features and about the means that are here, and you can use it in order to protect your ideas. And of course, at the very end, I will explain you something how to get some patent information out of the databases that are available. So first of all, we have to define what is intellectual property. Intellectual property refers to something which is not material. It's not of material nature, but is totally distinguished, and it's something very powerful just for the human beings. Only humans can have this intellectual property per se, because it represents an idea, and intellectual property is creation of the human mind. However, one cannot protect the idea per se. You cannot say, I have one idea, I have a great idea, but how I'm going to protect this? And I will try to lead you through this process in this presentation. So if you want to protect your idea, First, you have to protect your vision in a form of something that is tangible. You have to put this vision, this idea in a format. This format can be different, but once embedded in a suitable type or format, you can transfer the idea or concept to the intellectual property. So you have something to present. You have intellectual property, and you have intellectual property rights, which are the legal rights to use and continue with the exploitation of idea. I see very often that the students, but not only the students, also the employees, they mix what is intellectual property and what are the intellectual property rights. The intellectual property rights are granted, but the intellectual property per se is something that refers to the creation of the human mind. These are the types of intellectual properties that we can find around us. We'll talk later about the patents a lot, and this is the most powerful legal right for the new invention, and also explains why these inventions are important. However, I mentioned you at the very beginning. Can you hear me? Because I have a note that my internet connection is not stable. Can you hear me properly?
We can hear you. For a moment, it was not that good, but we could hear you.
Okay, stop me if something happens in a meantime, okay? At the very beginning, I present you with a little C at the front page of my presentation. This refers to the copyright. Copyright are original, creative, or artistic forms, which represent writing forms like books, articles, presentations, slides, music forms like symphonies, music parts, songs, and so on. Also paintings and different type of artistic works that are performed along with the history of the human society. So do we need anything to do to protect them? No, they exist automatically. What we need to do to have some copyright is actually to create something that represents a copyright. Something that represents the copyright could be a book. You have example of one of the book issued by our very well-known editor. You have to draw something, you have to compose something, you have to put some slides together to present those slides. You have the presentation. And I will mention immediately here how long does it last, the duration of the copyright. From the date of creation, it lasts for the whole life of the author. So composer creates a music symphony or something that is related to the music art. At the moment of creation, this is his copyright. It lasts during the whole duration of his life and can be extended 70 years after his death or after he passes away. So basically, copyrights can be inherited. So this is something to bear in mind, that this is a very strong intellectual property, although does not require any kind of protection by some authorities or by some legal body. What are the trademarks? I have mentioned at the very beginning, the trademarks are actually distinctive identification of products or services. They are used and they can be registered. For example, we have here the trademarks of the Rimac cars or car industry by one of our inventors, Mate Rimac. At the very beginning, I also said that we have a trademark of our winter school and we have the trademarks of our universities and so on. For how long does the trademarks, if you want to register them, registration, for how long does it last? It lasts for 10 years, but you can always renew it. And you have to pay something, and in order to register the trademark, you have to go to State Office of Intellectual Property, or maybe to European Intellectual Property Organization, or any kind of intellectual property body that is present on the territory where you would like to use this trademark. Of course, there are some costs associated with the trademarks. It is not that cheap in Europe, meaning that you have to pay 1,300 euros around, I think it's now the copyright in Europe, sorry, the trademark in Europe. For the United States is 3 times less, and also is half of this price, which you have to pay around 500 euros is in UK. So you pay some money, but you have your trademark protected and nobody can use it. However, when it comes to the trademarks, we have to bear in mind there are different forms of jeopardizing and infringing the trademarks. For example, trademarks are very powerful and they can be used for better selling of the products. Therefore, the competition very often will not completely imitate your trademark, but they could go to evoke something that is similar to the very well-known trademarks. So this is legally acceptable. Therefore, you have to bear in mind that the trademarks could be somehow jeopardized by the competition using these terms of evoking the same trademarks which are already very well known and accepted by the common public and by the market. Then we have registered designs. One can register the design, and I will show you at the end there are also design patents. Basically, you protect here external appearance, and the registration for this can also be performed within the state office for the intellectual property. It is quite unusual that every new product is put under the registered design. Some of the very well-known products are registered, others are not. For example, you have a lot of copies of Crocs or Crocs shoes or slippers, and they are not registered. They just evoke, like a trademarks, they evoke something that is similar to the original one. At the very end, it's something which is not the matter of protection. It's a trade secret. But however, this is a highly valuable information which should not be known to the public. And there are many, many reasons why you should really put a lot of effort to keep the trade secrets, to keep the secret of some production, or to keep the secret of some mixtures or formulas of recipes and so on. You know very well that nobody knows exactly the 100% formula of the very well-known spice in Croatia, Vegeta. Nobody knows only few persons know the formula, how and what goes, how the Coca-Cola is produced and what are the ingredients in it. The Coca-Cola actually has been produced in 1886 and protected in 1891. So we have more than 100 years protection of these beverages, but they have a very grounded reason why they keep this secret. When it comes to the recipes, cooking recipes, for example, these cannot be protected, of course, in any kind of tangible forms. These are also the trade secrets, and the cooking recipes actually are something that are matter of sharing between the people or keeping as secret by the restaurant or by the chefs. So far, so good. I hope it is. Any questions on this? Okay, we can proceed with the second one. There are a few examples of very valuable intellectual property. For example, you know this type of chair that is marketed under this sentence, the chair that grows together with you. So can be used for the small babies as well as for the working chair. And the producer is Strock. This is actually intellectual property protected by the patent, registered as a like a trademark, and sell under this brand name. You know the Harry Potter, this is authorship or copyright, another valuable form of intellectual property, which really brought a lot of incentives to the author and also to the publisher. One of the best sellers among the pharmaceutical industry is Bayer aspirin, which is known for more than 100 years already. I think 100 years will be very soon. In Bayer aspirin is used today for many other indications, and it's protected or by the application through the patents and extension of patents, and by the combination with the other drugs. And we have a different kind of this drug or the remedy available now at the market. One of the intellectual property is also PCR process, which is so-called DNA copying process. And of course, a very well-known brand is Coca-Cola, which I will mention a little bit more about. I will just go through the very simple bottle of Coca-Cola and try to explain once again which types of intellectual property are present in this product or at this very product that is presented on this right-hand side of this slide. So the brand Coca-Cola is a trademark. The formula is, I said, a trade secret. The logo is a copyright. And the shape of Coca-Cola bottle is protected both by design patent and by the trademark. They call this the trade dress. So we have 4 to 5 different types of intellectual properties present only on one product. But however, you know that this is worth, because bearing in mind the market and the sales of Coca-Cola, this is the best way how you will protect your product in order really to have a distinguished, to put a distinguished difference between the others. on the market, we can find a lot of products that are evoking, or some of them are already present for many, many decades also, evoking Coca-Cola, like a Pepsi-Cola, but they do not know exactly the trade secret behind, and the flavor of Pepsi is never the same as the flavor of Coca-Cola. Let's move to the patent. Patent is an intellectual property and represents actually exclusive rights granted for one invention, and it offers a new solution to a technical problem. So you have invention that can produce a new solution to the technical problem, and for this you can get exclusive rights to exploit this product. The patent is granted for invention relating to the product, process, or application. The patent provides the owner with the exclusive rights to make, use, place on the market, because it's territory determined, or sell the invention, license it for limited period, whatever you want to do with your invention, because the patent actually is a contract between you and the state office for a limited period of time, and may not exceed 20 years from the date of filing the patent application. I will explain this in details later, and I'm sure that this will be quite clear later on. This is not the rule also for the pharmaceutical industry. These 20 years can be exceeded when it comes to the drug discovery and development, and these 20 years can be exceeded for 5 years and also for 6 months if you have some drugs that can be applied for the pediatric use. The patent is acquired by the recognition of the authorized body. Authorized body is the state intellectual property office or intellectual property authority. The Croatian one is located at Vukovarska Street, and as a rule, based on examination performed by the patent application that is submitted first to the office, and this examination after examining the patent application and examining the invention that is described in the patent application, the law actually is that you have the authorized license or authorized contract with the state body that you can have exclusive rights to exploit and further commercialize, if needed, your invention. So patent is, once again, exclusive rights on the invention that has to be registered within the authorized body and has to be examined, like when you put the review papers, the patent application should be reviewed and then released. And once you receive the green light, you can really exploit your invention. What is important to say, the patent is valid for 20 years from the date of filing. Date of filing is the first date when you put your patent application to the authorized body. It's not 20 years after your patent has been granted. So 20 years from the date of filing. Let's move, and on this slide you will see what the patent documents look like. The granted patent documents actually has a different number here. This is a patent application, submitted to the European Patent Office. And this patent application consists of date of publication, date of filing. So from this date of filing, actually, the time starts ticking in order to really fulfill the 20 years of the patent duration. Here is the applicant. Applicant is also considered as an assignee. Abstract about your invention. This is a very simple water container for heating the water, so you can do whatever it's written inside here with this invention. Then you have the application number, you have classes, to which class it belongs, and also who is the inventor. Sometimes the inventor is really stated as a name, which is very usually the case in quite usual in United States. For the European Patent Office, for our region, for example, the inventor is very often the company for which the people work. And because all the inventions performed during your work period, according to your contract, can be a matter of actually they belong to the one that is to your employee, for example. It depends on the contract that you have, but everything is present here on this front page. And also you have different descriptions, background information, justification of your inventions, and then you have a sort of claims. We call them claims in a patent wording. Claims are actually really the statements for which you ask the protection by the state office or by authorized body of your invention. And at the end, it's good to put some descriptions to present your invention in more details with the drawings and references. We'll have a chance to see some examples later on. So the first example that I would like to share with you is recently I was looking into some products that we use in a lab. I was interested whether there is any patent application related to the centrifuges that we were planning to purchase. And I was able very easily to find a national application, which was a French application to the French state office, because the producer and the inventor are from France. This is the patent application filed later on, 6 months later, so submitted and filed within the US Patent Office. And you see that the number of the application is here, but it's not the same like the number of the granted patent. This could be different from US and Europe. In Europe, everything is the same. But the publication date, for example, here can tell you a lot. So the publication date of filing the patent actually was 3 years or 2.5 years before the patent is granted. How I know that this is patent application? It's written here, and it's A1, stands for application. How I know that this is patent? This is patent granted. So after 2.5 years, they were able, because this is a technical issue, to receive the granted patent, and it's written here like B2 in June 2017. So basically, out of this, just having the name of the producer of the company, and just having in mind what for what these centrifuges are specific. It's a kind of lead. They have a very specific lead and very specific mechanism of taking off the rotor. I just put 2 or 3 keywords into the searching into the database or into the basis where into the database where I can really retrieve for free some information related to the patents, and I was able to find this basically in less than half an hour. And you can also take the whole PDF and read the patent later on. Let's move on. The patent protection. Patent does not protect an idea. So patent protection is granted for the real solution to the technical use. In order to achieve patent protection, the invention and any field of technology must be fulfilled. 3 general rules and 3 general features should be fulfilled in order to be granted as a patent. All patents should be new. Being new means that it must not be shown to the public in any way, anywhere in the world before filing a patent application for protection. So saying something about trade secrets and about keeping really your information just for you and sharing your information, for example, with if you work for the University of Zagreb, you can go either to Vlatka and the Technology Transfer Office at the University of Zagreb. My dear colleague Smilka Vikic-Topic, from whom I really learn a lot about these things. She is in charge for technology transfer and also for collecting the patent ideas and trying to protect your ideas on behalf of the School of Medicine, University of Zagreb. But I know that Smilka always has a scheme or a template or of the NDA, non-disclosure agreement, or we call it also confidentiality agreement. You sign the agreement, and she's obliged really to protect and not to share your idea with the others. I will really encourage everybody who needs some help in order to file their patent application to have in place a sort of generic confidential agreement before starting to talk to anyone else, because this is the first prerequisite in order to file and to consider patenting. It has to be totally new information, nothing published before in a form of posters, in a form of presentation, in a form of publication, neither on social networks, nothing, because the examiners will check and they can find this information, and this can jeopardize your novelty. And the second step is equally important. In order to have a patent, which is very strong protection, you must show that your invention has inventive steps. It must not arise from the state of the art, which is obvious to everybody else. It has to have something inventive, which is not obvious to the others that work in a very similar field and are skilled in this field. So it has to be something that really shows that you have been thinking out of the box when considering patenting your idea or the new product. And it has to be applicable. Industrially applicable is actually the term that is used, but it has to be practical, not just theoretical. This is the best to say. So new, totally inventive, something really that shows that you have something unique in this product, and it has to be practical, not theoretical, pertinent and suitable for production or use in the industrial scope. So it has to be something that will be produced later on. This is the headquarters of European Patent Office in Munich. Actually, this is our, let's say, superior headquarters to our state intellectual property office that we have here in Croatia or in some other countries in the region. So European Patent Office every year has an election for the best invention based on the filed and submitted patents and granted patents. And I would like to share with you one example. And this is the example for the innovative solution and the award granted in 2014 for the very useful, unique, and really simple idea, although behind this idea and putting this in a patent and obtaining the patent required a lot of work. And you will see in this short video that Patrizia Paterlini Bresciò has developed a method which allows to separate the cancer cells from the blood, not from the tissues, from the blood. With just one withdrawal of blood, you can diagnose the cancer present in your body a decade before the cancer develops. And I have, there is a kind of music behind, but everything is written, and this lasts only a couple of minutes, and I encourage you to look at it. So I do hope that it was everything clear out of this very short video, which lasts 1.5 minutes. Actually, this scientist, she was able really to think out of the box. She knew at that time that the cancer cells are larger than the regular blood cells. And she developed a kind of filter in order to separate these cells out of the other cells and to basically have these cells in a separate compartment, remove the filter, and then you can analyze them and look into the origin of these cells. So this idea is really something new. It has a totally inventive steps because she introduced a kind of filter into the tubes, And it's also something that you can develop as a diagnostics or tool that can be used in everyday work in molecular laboratory or in biochemistry or in medical biochemistry laboratory or at the clinics directly. And this is something that really was recognized as a breakthrough invention in a field of oncology and biochemistry. And I'm really proud that part of this idea actually is also embedded in our new project, which we received and was granted by the Croatian Science Foundation and is now on the way. So we are dealing with the identification of the cancer cells related to the colon cancers, but exclusively out of the tubes and out of the blood. So blood is actually the window to the human body. And this is really amazing idea behind Patricia's work. So let's move on. Once again, in order to have the patent, it must be new, innovative, not obvious, inventive step is needed. And the third one, applicable or suitable to be produced and used in industrial scale up and used by the customers. Here is the example of azithromycin, which is the best known antibiotic and has been produced and invented by the Pliva scientists. I will come to this a little bit later, but what was the inventive step here? You know, more or less in a biomedicine, you know that we have 14-member macrolides like erythromycin, and this new macrolide developed out of erythromycin ring was actually the new 15-member macrolide. So the ring was opened and the new heteroatom was put, nitrogen was put here. And this was, and then the ring was closed, for example, by the chemist. This was enormous amount of work behind. The whole teams of Pliva worked on it, but 4 people were the most responsible for this idea and putting in place also all the chemical and medicinal chemistry work behind this. This is totally new and inventive step because azithromycin can be used once a day. Pharmacokinetics is fantastic for 3 days and you are rid out of pneumonia. Before the 14 members erythromycin macrolide, the generation before, used for the treatment of infection diseases was totally unstable, and its pharmacokinetics was not favorable and was not perceived as something that can be really used for the longer period of time. So basically this is totally new and nothing better than this has been developed in the meanwhile. Result is this is a United States patent contract between inventor and state office, or contract between Pliva in this case and the state office, and your asset is protected from the production by the others for 20 years after filing the patent application. So if the patent application was filed in 1979 or 1980, 20 years out of this, after this, the patent is valid, and for the pharmaceutical use and for the drugs, this can be prolonged for 5 years, and also for the 6 months if you have pediatric use and pediatric application. Why the patents are important and why we need to protect our idea in the form of patents? because they are totally essential business assets, because without a patent, you cannot bring out your business, because you cannot get the value out of your idea, out of your product. You have seen that Patricia has worked a lot on developing this kind of filters in a tube. 700 experiments were needed. But in pharmaceutical industry, there are a lot of teams. You will see how many experiments you need in the pharmaceutical industry to develop a drug. Then the inventions and the patents are increased funding for other innovative projects. You can invest them. They protect the small innovative companies, small and medium enterprises. One of these is the producer of headset, very small company, not far away from Zagreb. It's near Udine. And then there is a very well-known Sarah Blakely and her patent for Spanex. It's like underwear or lingerie, a new invention used by businesswomen mostly, and those working, and the people working, the women working in offices. And there is also a discussion going on whether or not to release all the IPs or all the intellectual properties to public domain under control conditions. This is always a discussion, and it's really something that is going on also right now related to the COVID-19, but I will also show you one example later. So to move a little bit faster, patents are your business tool because having a patent means that having had a patent application at least, that you have a clear idea what are you going to do with your invention, that you have subjected your idea to the state office who can examine it, that you have a trust in your idea because a lot of examiners will be looking into it. They will try to infringe it. They will try to dispute it. They will try to deny it. It's hard to get a patent. It's harder, much harder than putting a review paper or putting the scientific publication. Reviewers are dealing with large patent reviewers or examiners are dealing with the large databases, and they will find any kind of information published before your patent application, and this can infringe your patent and get out any chances to have at the end your idea protected. So it's really worth because can really protect your business. Having mentioning in I don't know when you apply for the project, if you mention that in a project documentation that your idea has been protected in a form of patent application, and you put the number of this patent application, or that you have a patent granted on your invention, this really increases a lot the chances to get the funds and to obtain the project. The same is when you talk to the partners, when you talk for additional money with the inventors, with the angel capitalists. They will trust you, believe me, more, and they're not going to be suspicious at all if you explain them very precisely that your idea is worth of patenting and that you have already put some steps ahead, that you have performed some steps before talking to them in order to protect your idea in a form of patent. But there are a lot of hurdles. So first of all, this novelty, or what is new, what is state of the art, or what is the prior art. So everything that is published before your date of filing can really jeopardize your idea, and you will not get the patent granted because the examiner will find everything what was published before. Here we have a very strange patent, but the patent has been filed in this form. This is actually the teapot with the two spouts, one handle and two spouts, which are basically based on the idea how the coffee machine works, espresso coffee machine works with two spouts and filling two cups at the same time. So nevertheless, something similar present in the state of the art would jeopardize this idea for the further development or further obtaining the further rights for the patent. So be careful, keep your invention totally confidential until you have filed your application. After you file the application, you can talk about your invention, but I would also encourage you to have non-disclosure agreement in place when discussing with anyone about your invention. Novelty is really that important that any kind of, as I say many times during this presentation, any kind of disclosure destroys it. For the novelty assessment, the patent application that have earlier filing date are highly relevant, and they should not be disclosed at all. When you file your patent application, for example, for the first 8 months, this patent application is known only to you and to the state office to which you have submitted the filing application. So nobody will be able to see this in the patent literature. And in a case that there is another publication in between, but this application is legally filed because it was not known at the moment of filing, because this was covered with the 18-month secret or 18 months coverage before the publication. The publication A actually will be the state of the art for the publication B, or in a patent dictionary, we call the state of the art prior art. So you must be very careful in order to really file your patent application as soon as possible, and bear in mind that at the moment of filing, for example, if this is you, it could be someone filing this patent application, similar patent application before, but this is not something that you can really influence a lot. Nevertheless, what can be protected as a patent? Device, compound, substance, product, production process, pharmaceutical composition, and then you have to explain use of compound X for the manufacture of drug for the treatment of disease. So you have to explain also why this compound is suitable for the further manufacturing, production, usage, or whatever. Why this device is suitable for the manufacturing or treatment of anything else, or help in some surgical procedures and so on. So in patent protection, there is a rule that no methods for treatment, particularly for the treatment of human body or for the treatment of animal body, can be protected. This is not legally acceptable, and it's not also ethically acceptable. But yes, the products, compounds, substances, devices that are used in these methods, this can be matter of patenting. In order to really protect your idea, even before you file the patent application, the official patent application, because filing the patent application costs a little bit and it requires a little bit more time for drafting the patent application. But let's say that you might encounter a situation that you would like to apply for some project, for scientific projects by or grants. You are allowed to file not a real patent application, but provisional patent application. And this provisional patent application, I decided to put this slide here because it's quite often that scientists taking this provisional application possibility at the time when they write the project application in order to see whether or not they will obtain further funds for the development of their idea. This provisional patent application is valid 12 months. And this is also one of the ways how you can extend your time of protection, because it's valid 12 months. And after 12 months, you have to file the real patent application. But within these 12 months, you will really get an answer whether your project is acceptable for funding. You can do additional experiments. And I would encourage also all of you working in this field of biomedicine that you should look also in this possibility. So 12 months, and after that, when you file the provisional application, so 12 months, after that, at the end of the 12th month, you can file the real patent application. And from that date, first filing, no priority. So from that day, you will have 20 years of the patent protection. But these 12 months will not be counted in the real patent life. These are the features which should be embedded in the provisional application. You see the title should be very short, 2 to 7 words. Background information, it's really a statement on the field of the art to which the invention is applicable, and is very short, should be very short. Some issues associated with the inventions, and for what this invention is applicable and which solution are provided with this. And the whole summary of invention is allowed to be, let's say, 3 to 4 sentences, very, very short one, but gives you this freedom to operate for 12 months, which is very good. What should not be regarded as an invention? You must be also aware of these things, that discoveries, for example, planets, scientific theories and mathematical methods cannot be patented. Any kind of aesthetic creations are, for example, this is Michelangelo's copyright, it's his painting on a famous chapel. This cannot be protected as a patent. All schemes, rules, and methods for performing mental acts or playing games or doing business, and usually computers programs cannot be patented, but it's optional because nowadays we have some exemptions, and these exemptions are in a field of softwares and in a field of some digital technologies that really can be patented. And there is a whole new study, master degree study in Hague and Rotterdam on these issues. And of course, presentation of information is a copyright, it's not the patent itself. Furthermore, there are some also examples which invention cannot be considered as patentable, particularly the ones that are totally contrary to the order public or morality. For example, any kind of cloning humans, work on embryonic stem cells, this cannot be considered as a matter of patenting. plant or animals or part of the nature that really are produced by the nature itself. But this shall not be applied to microbiological process and biotechnology process that I use. This can be patented in the United States. It's very often that you have a plant patent as well. And as I mentioned before, methods for treating the human or animal body, surgery, by surgery or other therapy, diagnostic methods that are performed on human or on animal body. This cannot be a matter of patenting, but they shall not apply for the products, as I said before, and for the devices that are used in these methods. And finally, the parts of human body cannot be patented. However, if you isolate a gene, you cannot patent it, the sequence of the gene in the United States, but in Europe you can patent this sequence. Particularly, you can patent if you have any kind of modification on the 3' or 5' ends of the sequence. This is matter of patenting in Europe, and this is the main difference between Europe and United States. There were a lot of discussion in the past with some sequences patented in the United States, and these sequences and these genes were disputed and were not taken into account as a matter of patenting. While in the while in the European Union, we can patent a gene. If you isolate it and you modify the sequence, you can put this in a claim. What about drug discovery and development? I would like really to cover this very briefly, and then we can have some questions and do the first break. Pharmaceutical industry today is really under the pressure, and when it comes into the patenting, the loss of IP rights is really significant in the last 15 years. And due to the fact that drug development and discovery is really costly and takes a lot of time, it's worth to consider patenting any kind of substances, procedures, formulation that might provide you an added value and prolong the duration of your business when you are in this kind of industry, because otherwise you have to merge with someone else and to find another investors for your business. For example, a couple of years ago, I think 4 years ago, Roche published these figures. They said that for one medicine, they employed 423 researchers. These researchers performed 6,587 experiments. They spent more than 7 million hours of work, and the whole investment was worth 1 billion Swiss francs. So it's a little bit less than 1 billion euros. Today, I show you an example on isolation the tumor cells. The scientist there, she performed 700 experiments. Here we have almost 10 times these figures, but we have this per more than 400 researchers. So working in the pharmaceutical industry is really challenging. It is nice. It brings a lot of advantages, a lot of knowledge, and a lot of experience. However, everything starts with one idea, and after the team is formed and you have the first compound, and the first compound produced, you test it in vitro, you have the ground to put a patent application. Why? Because if idea is new, it has inventive step and it brings applicability. You just need to have the compound for this idea, for example, or the solution, and test or confirm some activity. The in vitro activity, not in vivo, is enough to file the patent application. And the whole drug development process will last maybe 15 years. And this first couple of steps you can perform within a year and a half. So as soon as you have here at this stage your proof that you have everything needed to file the patent application, 20 years will start ticking. And at the end, when you put your drug at the market, you already have maybe 15 years, 10 years that have been expired, and you do not have a lot of time in order to really exploit your invention, because the phase 1, phase 2, and phase 3 clinical trials, they last for a long period of time. You need to involve a lot of patients into these trials, and time is money in the pharmaceutical industry. Therefore, the pharmaceutical industry has this privilege to extend the patent duration time for 5 years maximum due to the duration of the clinical phases, and also for 6 months if your drug is also used for the pediatric use, for those that have up to 18 years of life. So for the children and for the young people until 18 years of life. The patent application in the pharmaceutical industry is really something that is considered a top secret matter, and any kind of novelty is really kept at the very beginning, or with the contract that you sign immediately when you start to work for the pharmaceutical industry, that you will not reveal anything or any slides or any presentation at the conferences before checking this with the legal department. And delay in filing in the pharmaceutical industry can really jeopardize later on obtaining a real patent. So as soon as possible you file is better. Main features that the patent should be very clear, should bring the examples as well. The best definition of what you would like to protect is within the patent claims. These are the number paragraphs listed at the end of the patent documentation. So the patent in the pharmaceutical industry lasts 20 years from the filing date of patent application, plus 5 years if you obtain and you apply for the so-called supplementary patent certificate in order to extend the lifespan of your product or your patent, and additional 6 months. Yet again, I'm mentioning this for the pediatric population. These are the phases in patenting in any kind, but for the pharmaceutical industry, this is really important that you examine very thoroughly together with a skilled person in this professionals that work as a patent attorneys or your legal department or patent department. People are skilled not only in their field of science, they have basically some additional knowledge in the patent law, or they have a law school. A part of your original background. Any one of you can also be a patent attorney, a patent representative in order to really defend the patents and help others to drag the patents. If beside your school or beside your original background in a field, you also have some, or let's say at least a low school or 3 years of the school that will teach you how to deal with these issues. And so with the professional, you examine the prior art and very thoroughly and file very as soon as possible the patent application. Then in phase 2, you have to assure sufficient knowledge because once you file your patent application, you continue to work on your product, of course, and you will continue to develop your product. You will have a theoretical and experimental evidence in a phase when the examiners are going to ask you and will try to jeopardize your claims and to deny your claims. You will try to defend your invention. This is the same like communication with the reviewers, but a little bit more, let's say, sophisticated because the wording and everything is different. And at the end, you have your patent granted. The whole process can last a couple of years. So the first 12 months is priority year. And the first, as I said before, 18 months is actually something that is not that is protected by the law and by the state office from anyone else to see your application and to see your invention. But after 16 months, the search report, the first search report arrives to you, and you have to start defending your inventions. And also after 1 year, you can also apply for so-called PCT application. This allows you to really file the application within the 153 different countries who signed this patent cooperation treaty agreement. Here are the figures, how much does it cost? And let's assume that after 18 months, you have most of your claims defended. You will continue to defend them later on in a process because international preliminary examination report is coming during this period, and you will have really to have a solid theoretical and experimental data that are going to defend your invention. And then you will not for sure go and submit your patent application in all 153 countries. You will select, let's say, 5 to 6 countries for which you think that these are the most important in which you can protect your invention, because for each of them you will have then separately to translate your patent application into the language of the country, to Japanese, for example. For the European patent application, English is acceptable, but if you want to go then in, I don't know, in China, or if you want to go to the South America, this will need to be translated in Spanish and so on. So, and the cost will increase based on the number of pages you have, and also based on the number of countries in which you would like to publish your patent application, or later on defend your patent and have your patent rights, because the patent is not granted as a worldwide patent. The patent is only granted by one state, one country in which you would like really to sell your product or to place the production, or really to have exclusive rights to exploit your idea in this country. And you will not go worldwide because the worldwide patent does not exist. You will go really to the targeted markets which are very much of your interest. So protection in the phase of application may look very solid. You have, let's say, 30 different claims during the examination period. During the 2 years after application, you have a lot of holes in your claims, and out of 30 of them, you will have to reduce 10 of them because you were not able to defend them. But nevertheless, you have to really bear in mind what is important for your invention to be protected and keep this claim, maybe only one claim, by any means, and defend it in a way that you're doing everything to do this. Even go and talk to the examiners and to talk to the different state offices and their staff. And at the time when the patent is granted, you acknowledge for your work, and you can really place your product on the market of the states for which you have the patent granted. So this is again the cover page of the patent application. I've mentioned you already what has to be, but here what is important here is that this patent application is really publicly available 18 months upon the filing, and you can really search by the keywords and find all the patent application worldwide. Just a few words about the azithromycin inventors. We call them heroes of chemistry because they received in 2000 a very big acknowledgement from the American Chemical Society. They received this award called Heroes of Chemistry, which is equivalent of the Nobel Prize in Chemistry for the US, Canada, and American Chemical Society in general. This is Dr. Gabriela Kobrehel, Dr. Slobodan Đokić, Dr. Gorjana Lazarevski, and Dr. Zrinka Tamburašev. Gabriela Kobrehel and Gorjana Lazarevski, they still do some consultancy, especially Gorjana Lazarevski. Gabriela Kobrehel enjoys her retirement, while Slobodan Đokić, Professor Đokić, and Dr. Tamburašev, they have unfortunately passed away. So they receive, why it's this important to say that they are really heroes of chemistry. They receive for this patent, for the patent of azithromycin, the patent has been granted, and this is the date of patent in 1985. They received acknowledgement, and not only the acknowledgement in the form of awards, but also they were granted also with a certain royalties, which were not that small, because the azithromycin was able to get $2.5 billion every year out of the Western market, plus what was able also Pliva to receive from the azithromycin sold in the eastern part of Europe and India and China for the azithromycin or Sumamed as a brand name, selling drugs, and the amount of money received was really substantial. This amount of money really helped a lot Pliva to build up the whole industry and the production parts. At the beginning of the clinical trials phase, Pliva signed an agreement with Pfizer, and they offered them non-exclusive rights for the licensing. So they divided the territory where the final product could be is going to be sold once at the market, and also Pliva received with this licensing agreement 10% of the net royalties obtained from the Western market without doing anything. So if we speculate that each year for 10 years the net value of the income by azithromycin or Zitromax sold at that time in the western part was $2 billion. Every year, Pliva received $200 million on its account, plus the goods received from the Eastern market. So it's a big amount of money, but what is good should not be complicated. When you have a good thing, you will see that this is really fantastic, and you will recognize it immediately. This was the case with azithromycin. So the compound exhibit antibacterial activity with only one claim and with short abstract on 5 pages, with one drawing and one table on biological activity. They were able to receive US patent on this. And this was really a breakthrough for the whole country and for the whole region. Another patent we have, which is the example of something that I have to say here, it's a very brave patent, because with this patent, our member of the Academy, Slobodan Vukicevic, and his team were able to protect what? They were able to protect blood, autologous blood coagulum, which we say is a part of human body. Who can protect the part of human body? Only those people who has a bright idea and who has an inventive step behind this. So how, in this patent, is described how the human coagulum can be used as a carrier for the bone morphogenic protein. And actually, when this coagulum enriched with a bone morphogenic protein, a small protein produced in vitro, you can really develop bone out of the blood. And this was the basis, the main basis for the Osteograph FP7 project obtained in 2011. And this project actually was for the first time coordination granted to Croatian scientists by the European Union and extended for 60 months because it was extended in order to finish phase 1, phase 2A clinical trials. And immediately after ending up this project, before the project was actually officially closed, Professor Vukicevic submitted another project and successfully passed examination by the reviewers. And this is the project in which the ectopic bones can be also formed out of the blood enriched with bone morphogenic proteins, and they serve like pillars to stabilize the spine. And this one to reduce the back pain, pain in the back, which is a very huge indication. Osteoprospine is the name of the new project. This is and is currently underway. The clinical trials, phase 2B and phase 3 will start soon, and everything is done in 3 centers in Austria. So what are the advantages and disadvantages of patenting? I've mentioned a lot of advantages. However, because you have exclusivity, you have a very strong legal right, you can do whatever you can in order to enrich and to really exploit your invention, sell it, license it, and so on. But there are also a lot of disadvantages, of course, because you reveal to your competition what you have, can be very expensive because you have to maintain your patent rights in each country in which you have filed your papers, your application, and later on the patent. And it can take 3 to 4 or 5 years to grant the patent, in some cases even more. and because of that, one can consider other options. But we do not have at the moment time to consider other options. But you can find something that might satisfy your curiosity. At the European Patent Office, you have teaching kit, and you have the different materials which can really explain you very well what else can be considered. What do we have today? Today we have a situation with the COVID-19 outbreaks, and this COVID-19 outbreak really is creating a worldwide issue, and it's a challenge for all of the humanities. And the current initiatives that were put in the last month are coming out every day. And this is one that I took from the Wall Street Journal from this November, a week ago. Actually, the South Africa and India, they plan really with the big arguments to go to the World Trade Organization. This is within the World Trade Organization and the Trading Department in European Commission, that they should really waive all the protections from any kind of medication, not only the vaccines, any kind of medications that are aimed to treat COVID-19 infections. So whether or not they will succeed, they have a very strong argument and arguments in their hands. One of the strongest arguments is that scientist Salk, when he developed in the mid-50s his vaccine for the polio virus, for the child paralysis, I don't know, dječja paraliza we call in Croatia. He made this invention free for public, for the commercialization, and it was really cheap and available to everyone because he didn't want to put any patent on this. And it's very famous, his sentence, he said, patents? No, who can patent the sun? So he has considered his invention like something that is bringing light into life, and really he didn't want to put a patent on the polio vaccine. So this is the initiative also going right now, and we'll see how this will end up. In the meantime, I just would like to give you a 3-minute break, bio break, think a little bit about this, what I said before, and then I hope that in the next 15-20 minutes, I will cover something about the patent search, because I will just show you some screenshots. We do not have time to do anything interactively now. And I'm not leaving my position here. I will stay here. If you have any questions, you are more than welcome to put it. If you have anything to clarify, I'm sure that this is just a very brief overview, and I hope that I made myself clear, at least for you who are more or less in this area of biomedicine, and that you will consider something then we can stay also in touch for the future, and you can put the questions on my email. Are we still here? Vlatka, Anna?
Vlatka had to leave because she has another meeting soon, but I'm here.
So far, so good, Anna?
So far, so good. Great.
Okay, so one minute more and then we will continue. But I see 55 participants, so
Yes.
that's a lot.
We have a question in the chat, where to look at the already existing patents. Maybe we can wait for
this is something that will come very soon, in minutes or so. What else?
I think that's the only question.
Yeah, this is a very good question because people are reluctant to even consider anything from the patent literature. They think that this is something covered with a mystery, with the secrets and so on. But you see, after 18 months, all inventions are publicly available, and you can really retrieve the information out of it.
Yes.
So to move on, I will continue because I see still 55 people there. With this in mind, and this photo in front of us saying that everything is relative, I will just go briefly through patent search. So why search for the patent? To find out what the others are doing, to find new ideas, to see what is your freedom to operate, where you can place your inventive steps, to enforce your invention, because it's a very powerful base. Also, the patent database is free and it has a lot of information. First of all, 80% of the information that are available in the public space are within the patent databases. Only 20% are within the Medline, PubMed, and elsewhere. So 80% within the patent. Whenever I need some business also question, whenever I need, I show you one example. When I was supposed to get an information, I was looking for the information for one purchasing. I went into the patents because my colleagues informed me nothing is available, nothing is known from the ResearchGate, nothing was known within the Google search or Google Scholars. I have found some information on LinkedIn, but these were not relevant. So I went into the patents and I figured everything. So also 90% of this, 80% of the information is public domain. Everything is available. Only 10%, let's say, of the amount of information are those that are still protected by this time from filing until the public available information, 18 months. So you have everything available for free. Most of the patent databases for us are for free. For the professionals, you have a subscription on the databases, but this is something that goes into the matter of lawyers and into the field of patent attorneys. Reasons why you need to go and look into the great solutions is really to understand better what the others are doing, and maybe to help you also when you are doing some review or on some of some papers, or you are evaluating some projects. This can help you to see what is the kind of invention behind the one that is claimed as a new project idea or something like that. So very, very useful information. What you should consider is that when looking for the patent information, you can just try to picture in your mind what exactly you are interested in. Are you interested just to see the cover page and to see who is the assignee, what is the title, what is the short description, who is actually the inventor, or so on? Or are you interested in claims or in abstract itself, or only in figures or formulas, and so on? So most databases provide options for searching each of these items separately or together. I tried to do one search for one example. Basically, it's I was interested where the development of new formulation of resveratrol that were claimed as a great breakthrough in 2006, 2007, when Sirtis Pharmaceuticals was acquired by GlaxoSmithKline. At that time, I worked for the GlaxoSmithKline. We were in a GlaxoSmithKline Research Institute. Actually, Pliva Research Institute was bought by GlaxoSmithKline. And we knew at that time that they paid a lot of money, 20 times more, to buy the Sirtis Pharmaceuticals in comparison with the amount of money they paid for acquiring Pliva Research Institute. So I was really much interested, what do they have? And from ever since, I'm following the information which I can find, because it was really something very promising. So the resveratrol, the pigment or the compound found in red wine and grapes, red grapes, it has a very strong anti-aging, anti-metabolic syndrome, anti-deterioration, anti-oxidative properties, and so on. But it has a really disadvantage, because cannot be absorbed more than 4% per se in the gut. So the Sirtis has developed formulation where they have increased for 10 times the absorption, and they claim that they have a very good ADME profile. And they can treat many diseases related to metabolic syndrome, and they can develop the oral dosage forms, putting this resveratrol in a nanoparticles, and they can find also the way how to extend longevity and also combat, treat and preserve well-being and delay the aging process. So very appealing and very nice sentences were related to the compounds developed within the Sirtis Pharmaceuticals. So where to find the information? As I said, these databases are publicly available. You have a very well engine now developed within Google. Google Patents or patents.google, they provide you free information. Last year, I also presented this on the winter schools, but last year they didn't have this engine developed also to download the PDF files. Just be careful, because there is one disadvantage within this database. Look and read the privacy. So they keep the information on everything what you are looking for, and so they have your data, your you as a scientist, they have all your data, and they have all the information what you have been searching within the patent. So this is the privacy policy which you need to respect, and they respect this by providing you this for free. This is not the case on privacy with the European Patent Office. Recently, they have developed a new site. This site is called eSpaceNet, and really very useful, more than a useful, because it also provides you immediate translation on a different languages. So you can find, for example, patent in Japanese language or Chinese, and this patent is automatically by 2 clicks translated in a language that you understand. Then you have a World Intellectual Property Organization, or WIPO, website that you can really find a lot of information, not only about the patents itself. You can technology patents, you can find information on design patents, plant patents as well. So the new, actually the new sorts of the different varieties of plant development and so on. And you have also the United States patent and trademark office. Everything is for free. Let's look what I did with the citrus and what was the results of my search. So basically, I went to the Google patents, and then you start with the search terms. First, I put resveratrol, and I got, I don't know, more than 1 million results. And then I had formulations, nanoparticles, pharmacokinetics, and all these filters reduced the number of results that I received. Then I put oral, this even reduced more, and aging as, let's say, treatment of this compound, of this therapeutic solution. And when I put Sirtis pharmaceutical, because Sirtis pharmaceutical is ACME, I receive only 60 results, which is completely manageable. There are tutorials how to read and how to search through the patent documentation very briefly. I really recommend you to go and see these tutorials. So I took this first because these patents were sorted by relevance to see what is written on. First, when I click on this patent, I was looking into the images. So they have procedure here. They have one result obtained on the pharmacokinetics. And why I was looking into this, because looking into this can provide me also with a classification to which this patent is most related, but there are more than 52 classifications available to look into it. So this patent is basically related to the structure of the compounds with any radicals on it directly attached at the position 2 in a cluster, in a scaffold that belongs to the resveratrol. I was able, as I said, through Google to download PDF. You see here that there are 2 other languages available, German and French, but this is not that important because you can just take this number, or you can just take any kind of keywords or citrus or resveratrol and go into the SpaceNet, and then you can really translate if needed. And you can see where the worldwide applications have been applied. So they do not have a lot of countries, but they have, for example, Spain here still valid. So, and they do not keep this invention anymore within the United States. So they are not paying the fees for this invention. And then I was interested a little bit more who really paid for this patent and how long this patent is, how large it is. And then I downloaded the PDF. This is the first page of the PDF, and this is the second one. On the first page, I was able to see that this is really a granted patent, B1, it's not the application. The date of filing in 2006, so at the time when we were basically together with GSK and in the phase of negotiations, and so also the CITES was one of the players to be acquired by GSA. So this is the date of filing, so they have protection for minimum 20 years if they pay all the fees in different countries. Then I also look who is proprietor is Sirtis Pharmaceuticals. But this information was very valuable for me, who was the representative, because this patent was written and the representative of this patent was the GSK person working within the Global Patents Department. So GSK paid for this patent, and you see this patent is very large. It has 310 pages. And when looking into all of them, I have seen that they have a lot of description, background information embedded in it, and they start with their claims at the page 297, almost at the end, because then they have the drawings and also the references. They have only 14 claims in total related to this compound and the use of this compound. So a very expensive patent, because you want to patent it in, I don't know, in Argentina, for example, or Brazil. You have to translate all these pages in all these documents in Spanish, and you have to pay a regular yearly fees for the maintenance and so on. Just for one country, it's a lot of money. And I was wondering whether or not this is feasible in today's world, because today we were told while working for the European Commission on some projects, I encounter and I come across very often with the people who are also the patent attorneys, and they said that, and also my colleague from whom I learned a lot, Gordana Turkal, who actually is a patent attorney, and she's the official examiner at the Croatian State Office, but also she's our representative at the European Commission and European Parliament on behalf of Croatia. She always says that more than 20 to 50 pages is really expensive. Today, we tend to really reduce the number of pages of the patent, and this is not anymore the way how we should approach when applying for the patent. So what next? If not Google Patents, you can search the patent on eSpaceNet. You have 120 million documents, a lot of them. On Google, you can find the patent documentation and the publicly available documents as well, so the publication. Here you can find a very good different sort of patents and different sort of information from this eSpaceNet, and it's very easy for you also to look and search at this database. For the trademarks, you can search in Trademarks View, in eSearch Plus, and I will encourage you all the time that you should search. Can you hear me? Can you hear me?
Yes.
Can you hear me?
Yes.
Okay. That you always should look for the professional advice, because the professional advice will really help you draft your patent application. Any kind of questions and doubts you might have will be resolved, and better to resolve them as soon as possible with someone who really has experience in doing this. It could cost a lot, not a lot, but some amount of money. For us, everything counts a lot, but it's worth, because if you file something wrongly, then it's very difficult to really put the whole, I would say, endeavor in the right track later on. So go and look for the professional advice. To the University Technology Transfer Office with Vlatka and the team there. Ask Smilka Vikic-Topic if you are related to the biomedicine, and you can also go to the state patent office, and then you have a possibility to ask the questions and to get some help. This is the eSpaceNet. This is the feature or the screen that is present right now, but this will expire very soon because they have moved to the new interface, and which is really more compliant to the clients and more related to the scientists and use and better to use. And this is the new front page of the eSpaceNet. You have really here a couple of things that you can use and really get very soon the relevant information. You can immediately put advanced search. You will have the scroll down menu, what to select. You can search by classification. I didn't have time to explain you exactly what the classification is, but could be related to the compound class, to the material, to the use, could be related to the therapeutic area and so on. And it's not an issue to play with this and to spend some time during this isolation also on this page. And for your homework, you can play with the eSpaceNet and look into all forms of azithromycin. You will see how many forms the Pfizer has protected. And what is also interesting to say is that the Pfizer still holds the production here in Croatia at Savski Marof. So we are producing azithromycin or Zitromax for the whole world here in Croatia. You have a specific examples with the design protection. You can find the oldest patent design for the Coca-Cola bottle from 1915, and then how this evolved along the time. But it's really interesting also to go to the WIPO, World Intellectual Property page and search for the patents, because you can find here something really interesting, how to protect choreography and how to protect movements. For example, how to protect the yoga program and the copyright. You have a lot of articles there. You might be interested, maybe between us, we have someone who has some experience in I don't know, in ballet or in some choreography. This also can be protected. I hope that, yeah, I was not able to answer all your questions. It's much better when we stay together in the same classroom and discuss this, and then I can really show you some really papers and some tangible material in front of me. I always have with the students, and but this is the situation now, and I'm really happy to help you with any type of questions that you have, and then really to steer you and recommend you to the others that are basically the expert in this field. I'm one of you, I'm the scientist, but during my work experience, I was really very happy, and I'm grateful that I had also this dimension with the patents, because it helped me a lot nowadays, and not only during my industrial time, but also during my academic time. A lot of questions I solved, and I was able to find the answers in a patent databases. any kind of questions? Any question? Anna, can you hear me?
I can hear you. I don't see any more questions, new questions in the chat.
I hope that we answered the question that was put before at the break. So with this, I'm just wish you to stay safe and healthy and see you in a real world, in a real time, in person as soon as possible.
Thank you, Donatella, for a very nice lecture, and thanks to all participants. Thank you for joining. I hope that some of you will join us tomorrow or the day after that for other events of winter school.
Bye-bye.
Bye.